Good senators, the patriotism, faith, and abilities of this Senate are unbelievable. So how can we be so divided, seeing the same issue in such different views? The vote on this bill before us is one of the most monumental decisions we shall ever make. To me and many others, the vote on this bill is a question of the start of slavery or freedom. Because of this, my hope is that what I'm about to say will not be disrespectful to anyone on the floor, since I believe that I'm following the path that God has chosen for me to defend my country, my state, and my family. Most of you here are more experienced in the battle of politics than I am, but I must speak according to my beliefs, my heart, my knowledge, and my personal experience. Due to the way the Affordable Care Act was written, it depends on the existence of a state exchange to impose the tax penalty. The state has no control over this. There are many authorities that conclude that the employer mandate applies only in states that create and fund their own exchanges. And Mr. President, if I may quote out of the Heartlander magazine dated 1/10/13, I have about 3 quotes.
Having identified the source, the senator may read.
Morris Thompson, director of the Center of Constitutional Law in Ohio, says, quote, "Under a strict reading of President Obama's law, the states must set up exchanges in order to enforce the mandates and distribute the subsidies. The law does not authorize the federal government to offer tax credits or subsidies through its own exchanges. Rather, it continually refers to, quote, an exchange established by the state." In the same article, Jonathan Adler, a professor at Case Western Reserve University School of Law, concludes that tax credits and subsidies for the purchase of qualifying health insurance plans in state-run exchanges operate as the trigger for enforcement of the Act's employer mandate. He says further that the IRS rule amounts to a new tax that wasn't authorized by Congress. In the same article, the much-respected Congressional Research Service, and there is a handout on that for you, is a nonpartisan group that works exclusively for Congress for over a century. And they noted that without the state-based implementation trigger, there's no tax penalty. And an IRS interpretation that extended tax credits to those who enrolled in federally facilitated exchanges would be contrary to clear congressional intent and likely being deemed invalid. There are many other authorities that are saying this, like Heritage, Cato, ALEC. So in other words, the taxes and penalties threatened to be imposed upon us for not buying insurance, as defined by the Affordable Care Act, are dependent upon each state establishing a state exchange. Without a state exchange in Idaho, there are no penalties for Idahoans. So we continually state that we will have more control with the state exchange. Just how much control does the state have with the state exchange? I want you, if you're willing, to look at the papers I handed out to you today as I walk you through them if you have not already done so. These 4 pages are from Obamacare, dealing with state exchange flexibility, regulations, cost, and enforcement. So on the first page, it starts out with state flexibility. And you could look that up on the website if you want to follow on the website. The website is right there also. And I'm going to use quotes out of this, or follow this partly, if that's okay, Mr. President.
Having identified the source, the senator may quote.
So, in general, the Secretary shall issue regulations setting standards for meeting the requirements. A, the establishment and operation of exchanges, including shop exchanges. B, the offering of qualified health plans through such exchanges. C, the establishment of the reinsurance and risk adjustment programs under Part 5. And D, such other requirements as the Secretary determines appropriate. And number 2, under consultation, if you will notice, under 1 it says the Secretary shall consult with the National Association of Insurance Commissioners and its members, with health insurance issuers, consumer organizations, and other such individuals as the Secretary selects in a manner designed to ensure balanced representation among interested parties. There is absolutely no consultation with the states regarding establishment of the exchange and the insurance products that are being offered on the exchange. The term flexibility in the title of the section was put there to fool us to think that some flexibility already existed. B, each state that elects at such time in such manner as the Secretary may prescribe to apply the requirements described in subsection A, and then 1, it goes on, the federal standards established, and 2, the Secretary determines. So we have the right to build the store, but we have absolutely no control over the products that we're going to sell. So there's no real flexibility. Then the next section, C, failure to establish, exchange, or implement requirements. If you go down a little bit, it says, the Secretary shall, directly or through agreement with a not-for-profit entity, establish and offer such exchange within the state. Now, it's important to note here that the exchange established by the federal government is not referred to as a state exchange. Rather, it's simply referred to as an exchange, and this is what I was referring to in my other quotes. If the Secretary wanted to call it a state exchange to clearly indicate that whether it is established by the state or by the federal government, it is still considered a state exchange, the wording would have been much different. However, it simply calls the health exchange established by the federal government as exchange. So there is a difference between exchange and state exchange, a difference that has huge implications. Then we have under enforcement authority. We have D, and it says, no interference with state regulatory authority. Nothing in this title shall be construed to preempt any state law that does not prevent the application of the provisions of this title. Is that clear to you? It's very confusing. I think if you take out the word not, it says the opposite of what's supposed to mean. So, I mean, if you take out the word not, it says what it's supposed to mean, flexibility, but it doesn't. It includes the word not. You try reading that one. It's very confusing. Then in the next part, in general, it says the Secretary shall presume that the exchange meets the standards under this section unless the Secretary determines after completion of the process established under paragraph 2 that the exchange does not comply with such standards. And number 2, process. The Secretary shall establish a process to work with the state to provide assistance necessary to assist the state exchange in coming into compliance with the standards for approval under this section. So that's the entire section on flexibility. So unless you see something clearly articulated in there, we can't do it. You may hear many benefits that the state will derive from setting up their own exchange, but just because we want it so doesn't make it so. And then it gets worse. We could go through some additional federal requirements that are being put upon us if we adopt a state exchange. In fact, you might find it interesting to put in the term each state shall in the website and review many of the requirements that are put upon the state exchange. So some additional federal requirements if we keep going. Section 1252. Rating reforms must apply uniformly to all health insurers and group health plans. Any standard or requirement adopted by a state pursuant to this title or any amendment made by this title shall be applied uniformly to all health plans in each insurance market to which the standard and requirements apply. Section 2002 is transition planning and oversight. If you read there, each state shall submit to the Secretary for the Secretary's approval the income eligibility thresholds. Then the third part, cost. In a letter to Governor Otter from Kathleen Sebelius dated January 3rd, 2013, if I could quote out of that, Mr. President.
Having identified the source, the Senator may read.
State exchange requirements. Each state exchange must demonstrate legal authority for all necessary state-based exchange functions as described in the Affordable Care Act, including financial sustainability and the appropriate authority to certify quality health plans by March 15, 2013. Does this sound like a federal government who's willing to assume all the costs for establishing and maintaining the exchange? And then number 4, under the Obamacare Act, risk adjustment 1343. Number 1, each state shall assess a charge on health plans and health insurance issuers. Number 2, and this is not on your paper, is high actuarial risk plans. Each state shall provide a payment to health plans and health insurance issuers. Then Section 1413, streamlining of procedures for enrollment through an exchange and state Medicaid CHIP and mental and health subsidy programs. Under 1, each state shall develop for all applicable state health subsidy programs a secure electronic interface allowing an exchange of data, so forth on that. Under enforcement, Section 1401, I just want to point you to number 2, premium assistant amount, and it says here, all monthly premiums for such month for one or more qualified health plans offered in the individual market within a state which cover the taxpayer's spouse, or any dependent of the taxpayer in which were enrolled in through an exchange established by the state under 1311 of the Patient Protection and Affordable Care Act. What I want to point out here is this terminology we see is, I've referred to before, is that only through a state exchange, an exchange established by the state, needs to be pointed out. It's not such exchange within the state, so there's a difference between the two exchanges. As that one, as such exchange within the state is quoted in Section 1321, the part where it says for failure to establish an exchange. So there are differences between the exchanges. And I don't know if, you have actually viewed that before. And so that was one reason I wanted to go through that. So it gives us an opportunity to take advantage of seeing whether what we think is really what is. Does the state exchange give us control on life and religion? Does it have flexibility over costs and regulation? So again, my concern is that there's no explicit protection for unborn life and for freedom of conscience in HB 248 because of mandatory health insurance coverage of contraception, sterilization, and Plan B and ELA. The state has no control over preventative services. Forcing us to buy insurance through a state exchange is an attack on our religious freedom and conscience rights, since there is no opting out of these preventative services in the required health benefit plan set up by HHS. Because of Idaho's abortion opt-out language passed in 2011, the Attorney General's legal opinion states that under a state or federal exchange, our insurance companies may not provide coverage for surgical abortions or RU 486, but under a state exchange, they would be required to provide for Plan B and ELA since they are considered contraceptives. But Plan B and ELA are also potential abortifacients since they can prevent implementation of a fertilized egg, an unborn baby. In an academic review dated February of 2013, LifeSite News by Patrick Crane, Mr. President, if I may use that source.
Having identified the source, the Senator may read.
Dr. James Trussell, a member of Planned Parenthood's medical committee and one of the leading authorities on emergency contraception, has said that doctors have a duty to inform women that emergency contraception could prevent a newly conceived embryo from implanting in the womb, therefore an abortion. Insurance companies will be required to provide coverage for emergency contraception, whether we have a federal exchange or state exchange, but the employer mandate tax can only be imposed upon the state exchange. So if the tax cannot be imposed, then one could avoid paying for insurance that is against life, liberty, and property. In 2010, we passed the Health Freedom Act. And in 2002, by passing SJR 104, the legislature petitioned Congress to reject the HHS mandate that required those who sponsor, purchase, and issue health insurance plans should not be forced to violate their deeply held moral and religious convictions in order to take part in any health care system that violates their belief in the sanctity of life. Senators, it is our duty of state government, according to statute and code, to protect us. Our lives, first of all, and our freedom of religion, and the most cherished of American freedoms, our religion, freedom of religion. Are you willing to leave this up to the mercy of the federal government that is now the most anti-life government we've ever had? I ask you, what is more important than protecting life? If we who are a pro-life state cannot even vote for a pro-life, pro-religious freedom amendment, what control do we have? If we do not protect life at the state level, then we have no rights at all under our state government. We need to say no and wait. It does make one wonder what motives are behind the push for a state exchange if we have no control over life. What monetary or political gain is there to go against life, liberty, and property? Good senators, many of you have said that your heart is with us on these issues, and I truly believe that. But will you join your hearts to your faith and these facts and join us? George Washington said, "Of all the dispositions that lead to political prosperity, our religion and morality are the indispensable supporters." In a world without God or religion, the strongest thing is the state, and especially and most obviously the state that banishes God. We are bending the knee before the secular state. Thank you, Mr. President.